Greetings, everyone, and welcome to another episode of the TCLF One-on-One Series. Through this series, we interact with pioneers and stalwarts of the legal world from India and around the globe. And today is no exception, as we have with us Mr. Lomesh Kiran Nidumuri. Sir is the partner at Cyril Amarchand Mangaldas and is the head of the disputes practice at Cyril Amarchand for South India. He is also a key member of the international arbitration team at the firm and has the experience of working at other notable law firms such as IndusLaw. Sir is an esteemed alumni of the Delhi University and the New York University. Sir, it is my genuine honor to have you here today.
Thank you so much, Aditya, for having me here. It's indeed a pleasure.
So, sir, before we get into our discussion for today, which revolves around arbitration in India, the challenges it faces, and the reforms that could be implemented, I think it would be great for our viewers, which are predominantly law students, to know what was your inspiration behind getting into law. What inspires Mr. Lomesh to get up and practice arbitration every day, head to the office every day?
Well, thank you so much, Aditya, again for having me here. And I think the whole purpose of me doing this interview is just so that law students can benefit a lot. And the idea is really that law students learn a lot, not so much from my so-called successes, but my failures. And some of the things that I have done wrong in my life, some of the things where I needed clarity in life, some of the times in my life when I felt I needed a lot of direction and I did not get it. But I always felt that there was some kind of a push that was supporting me like a guardian angel. And I just want to share as many stories and anecdotes as possible with you and the audience, just so that they get a little more perspective, even if they take one or two key takeaways from this conversation. I'll be very, very happy with that. Now, to answer your question, what keeps me going? I think the whole thrill of practicing law itself is fantastic. I take law to be like a game of chess, and chess is something that's very, very dear to me. I used to play a lot of chess as a kid, and I see a lot of chess in real life practice of law and also life. And I'll tell you what keeps me going every day. What keeps me going every day is the fact that a client has trusted me to give top quality service to him or her and to do certain things before a court or an arbitral tribunal. That's what keeps me going. The fact that every day I wake up and I realize I don't know much and that I need to keep updating my skills, updating my law, updating my knowledge, and to constantly keep learning, that keeps me on my toes. And that also keeps me humble, knowing that no matter how many years you put into this profession, you'll always continue to be a student of law. I think that is a very humbling experience, and that is something that keeps me going. Coming back to the chess analogy, what keeps me going is the fact that on a daily basis, consistently, every minute, lawyers, especially disputes lawyers, are always thinking. And because you have an opponent, unlike most other professions where you do not have an opponent, here you have an opponent who's trying to prove your case to be wrong. And you have a judge or an arbitrator who's deciding the case. So there's a human element as well. And you are researching, you are going deep into the law, analyzing your facts, analyzing the law, advising the client. So there's an advice and human element of advising your client and taking your client along with you, that aspect of it, which requires a different skill. Your skill and ability to understand and appreciate the nuances of law and the facts of the case and to apply it in real life, that is also a skill that you practice. And knowing what the other side may move, like a game of chess, what are the possible moves that the other side could do, and what are the ways in which you can do better in order to get over what the opponent is intending to do, is also something that excites me. And I can go on and on. The thrill of having to appear in court, the thrill of cross-examining a witness, the thrill of just the art of advocacy before a court or an arbitral tribunal. I think that is always an exciting thing, and it's an ongoing process.
That's a very well put answer, sir. And I can see the sport has had a huge influence in your life. For chess, for example, even badminton, you're an avid follower and an ardent fan of badminton. You also co-own a team called the KGF Wolves in the Grand Prix Badminton League. I would like to delve onto that and ask how much of a role has sport played in shaping the kind of personality that you need in order to succeed in the field of arbitration, in the field of disputes in general. And how much would you advise that students who would view our conversation today, how much importance should they give to sports in order to succeed in practice of disputes?
I think sport has played a huge role in my life and in shaping my personality in general. So when I was a teenager, I was largely confused like any other teenager, right? So you don't know what you're next. You don't know what you're going to do next. So sport was a great outlet for me to release a lot of those pent up energy that I had, and understand what it is like to work in a team, to work in a group collaboratively, to make sure that you reach the intended target. Sport also taught me, again, humbling experience, because while I was good at a lot of sports, I was never really a master at any. I was not good enough to play either at the state or the national level. So a lot of rejections came along the way, right from my college team. I went to the St. Joseph's College of Commerce, which perhaps has one of the best cricket teams in India. You had all the big Ranji players, including Rahul Dravid from St. Joseph's College. So obviously, it was a very humbling experience for me. And in grade 10, I thought I would play for India. If anybody asked me what my ambition was, I would say I want to play for India. No, but soon I realized that I was not good enough to play at forget about the national level, but even the state level. But the fact that I harbored that ambition, and the fact that I worked towards it, and the fact that I got rejected in my college team was one of the motivating factors in my life. I realized that you're not going to succeed at everything that you do, and there are lessons that you learn even from defeat. And it also taught me how to accept defeat in life with grace and with a lot of gratitude, and to keep marching forward and to keep looking forward no matter what. Litigation is a very hard profession, Aditya, as you know, and a lot of viewers also would know.
Yes, sir.
It is not for the faint-hearted. But there is a lot of thrill and challenge in litigation that I do not see in any other profession. In fact, I don't see any other profession in this world which comes close to the thrill of being a litigator. And that, again, I come to the sports analogy, because you're constantly under pressure. A client who comes to you is constantly under duress, is constantly under pressure. He's not going to come to you during happy times. He's not going to come and say, happy times, I'm here and I need some help. No. Everybody's in trouble and everybody needs advice quickly, and they need results also to be done quickly. So your ability to handle and soak in a lot of pressure, not from one client, but from multiple clients who walk into office, ability to soak in that pressure, ability to think on your feet quickly, ability to churn out drafts quickly, and ability to have a result and success-oriented approach on behalf of your clients, because you give it all to your clients. And that's the kind of attitude that you bring to each case, that you never say never. And even if you have failed on a particular day before a particular judge, you still get up again the next day, and then you fight the same case before the same judge with even great vigor. And these are all things that comes from sports. And the other thing that sports teaches you is that you have, as I pointed out earlier, like a game of chess, you have an opponent. Your opponent is always trying to go one up over you. So they're always trying to research more. They're always trying to put in more effort. They're always going to think of points that you have not thought of. So it's all the more important that in your strategy discussions with your client, you always think about the nuances, both the pros and cons of the case, and try to second guess what the other person might argue in a court or arbitral tribunal, and be one step ahead of the game. And lastly, most important, what sport teaches you is, no matter the fact that you have an adversary on the other side, and you have a judge or a tribunal who may not 100% be with you, even if a case goes against you, you learn to lose with dignity and honor. And you shake your opponent's hand, you trust the process, and you say that a better person won on that day. So these are all some of the facets that I would say that sports teaches you in your day-to-day life.
I cannot put it any better. The rejection is one of the biggest teachers that you have in life. It inspires you to work harder for the next day, wake up to a better morning. And if I would continue this analogy into the field of arbitration, that is your specialty, how would you, obviously you are a pioneer, stalwart of the field, but there must have been times where you would have faced failure or rejection in the field of arbitration. In general, what would you like to share with us about your journey in the field of arbitration, as the field itself is growing today in India, and it is also learning from its mistakes, what would be your encapsulation of your journey?
So, I mean, I would call it a journey, not just as an arbitration lawyer, but just as a lawyer in general. If I have to just put it very, very generally, I'm a first generation lawyer. So I have absolutely no godfathers. So when I told my father that I want to do law, he was very categorical that you're choosing a path that I may not be able to help you in. It is, you have to make your own way. I was very fortunate in the sense that at least I had 3 meals. I could have 3 meals a day, and I had a roof over my head and reasonable pocket money for me to go out and have my share of entertainment, which a lot of other friends of mine were not privileged. We take all these privileges for granted. So life was not easy, even when I was in college. So I would keep staring up and thinking and have conversations with my other friends who are first generation lawyers as to what our life is going to be once we start law. And how is it going to be? Because you obviously had people from more privileged backgrounds who had it pretty much sorted the day they entered law, the day they entered law school. They had it all sorted because all they had to do was join XYZ chambers or join their own father's chambers. It was very easy for them. But I think now looking back, looking at all those days when, which were so uncertain, all the times where I have walked to law firms and dropped my resumes at law firms for internship because I didn't know how to approach internships. And we didn't have a very robust internship mechanism. So I would go to law firms pretty much door to door and hand over my resumes, and obviously got no response. But life again is wonderful because the moment you get those opportunities, one door leads to another. And when I was practicing in the Delhi High Court, for instance, I worked with the Central Government Standing Counsel for very, very less money. In fact, the money that I was getting did not even cover my rent. And embarrassingly, I had to ask my father for, telling him that, at age 23, please, 1 year, you please support me. From next year, I'll be on my own. But I was very privileged and lucky to have great parents who supported me in my initial years. And the first year, I basically largely lived off my parents' money. And then I was arguing a matter in the Delhi High Court. And this is my first year itself, I got an opportunity to argue. I don't remember which judge it was, but somebody saw me argue the matter in court. And that person happened to know a leading lawyer in Bangalore. And that person got to know that I was actually applying to law firms in Bangalore, and there was a recommendation which was made saying that I've seen Lomesh, he's good in court, he seems to be okay. Will you take him? And that opened up a window for me to start my work again in Bangalore under the aegis of Mr. K.G. Raghavan, who is a leading senior advocate in Bangalore and who boasts of having the best lawyers that Bangalore has around today. Most of the law firm partners or most of the senior advocates who are doing really well today are all from his chambers. So I was very fortunate to be working in those chambers, which had the likes of Dhyan Chinappa, Pramod Nair, George Joseph, Ganapati Hegde, Arun Kumar, all senior advocates and doing extremely well today. I got that opportunity. And from there, I had to work really hard. And then the same law firms which rejected me for internships just 3 or 4 years back, the same law firm partners become your friends over a period of time, and they come to you for advice. They say, Lomesh, this is a sticky point of law that I have. Can you please guide me on this, or can you please help me? It's a gratifying feeling. So nothing comes easy. Life comes around a full circle. While doors close on you in the initial bit and things look really hard, I think with just a lot of hard work and perseverance and consistency, I think that is the key. That is perhaps even more critical than hard work. The fact that you're consistent and you're persevering every single day. And then the doors opened up and I was able to, catch up with the same people who rejected me in the past. So it's been a fabulous journey. So like this, there are multiple challenges, Aditya. I can go on and on.
No, I can't agree more. Like the journey of law is hard work and consistent hard work. You have to be persistent in your effort. So, in such efforts, in such a journey, is there anything you wish you would have done differently, or is there anything you would want students of today to learn from your mistakes? Anything that you say that this part of my journey I could have done in a different way?
Well, honestly, I don't have too many regrets because I think there are some things I did right. One of the things that I did right was the fact that I did not get into a rat race. Uh, I think I feel bad for students today because the number of law students have increased. There is a lot of law students who are entering into the market, and the spots obviously are very limited. And I can pretty much sense the desperation in law students today to get one above the other. And my advice to them would be that one, don't get into a rat race. I know that it's easier said than done, but ultimately look at it as a game where it's a marathon, not a 100-meter sprint. You will have to pace yourself for a really long innings. On the cricket parlance, it is a test match innings. Imagine that, it's a first day in Lord's green track. That is perhaps going to be your first year of practice, first couple of years, where the ball is seaming around and you have absolutely no idea. But then as your years get better, day 3, day 4 pitch, it's going to be a belter of a wicket to bat on, and sky is the limit insofar as success is concerned. I would say that, you just have to stick to your strengths, understand what your strengths are, know what you need to do, and just stick to it and stick to the basics. There's nothing really complicated about all of this. And now with technology coming in, with the use of artificial intelligence, with the use of other technology tools which are available to students, it's only going to get easier for law students to even excel even further. I think technology can be an enabler. I don't see it as too much of a disruptor. It is going to be a disruptor, maybe to an extent of doing the basic work like diligence, etc., but largely it's going to be an enabler, and it's only going to be like fantastic times ahead for law students ahead.
That is great advice, sir. And if I may move on to the challenges that you faced in your journey, what do you think are the challenges that arbitration in India faces today? What are the main challenges that it faces today in our society, in our legal firm?
Okay, so I'll have to keep this short because there's quite a bit to talk about this, but I'll keep my answer very short. One, I think, which I think it has improved, but a lot more can improve. One is the mindset towards arbitration, and that starts with the lawyers themselves, and to not treat it merely as a job that is done after court hours, but to look at it as a serious arbitration profession itself, where you have a proper arbitration bar. We keep talking about creation of arbitration bar. That is very, very important. The mindset needs to change. The second thing is obviously on the legislative space, there were some amendments which were lacking. And now the Law Commission has given a couple of reports, 2015, 2019. There's a further reforms that is likely to happen to the arbitration law itself. That is much needed. The third thing I think is the need for good quality arbitrators. I mean, the pool is extremely limited right now. Barring a handful of retired High Court or Supreme Court judges in select jurisdictions across the country, you do not have quality arbitrators. And I think that needs to improve rapidly. So that can only happen when you increase the base by getting in a lot of younger professionals as well as arbitrators, and not just younger professionals for the sake of it, for the sake of having some diversity. I'm opposed to that. I believe that it has to be truly based on merit. And the younger professionals also need a lot of training on how to deliver awards and how to conduct yourself as an arbitrator. There has to be some kind of an institutionalized mechanism for it, because I can tell you from experience that being an arbitrator is not easy. It's very easy to be a counsel. Drafting an award, an international award, is not easy. It takes effort, and it requires a lot of learning, and may I say a lot of unlearning as well. So I think there's a desperate need for that as well. Then the other thing I would say is in terms of arbitration is, I think there is a need for having proper infrastructure in a lot of arbitral institutions. For instance, something as basic as transcription services. This is not something that is easily available in most arbitral institutions across the country. Most of it is just question answer, where you have a steno who types the question and then the answer is typed. So in a 2 or 3 hour period, maybe about 50, 60 questions are typed if the stenographer is good. Otherwise, sometimes you're stuck with 20 questions. And that really is not efficient way of doing it. The best way to do it is to replace all of this by just having transcription services. And I think a lot more use of technology needs to come into arbitration. You need to have world-class, fantastic arbitral institutions that have state-of-the-art facilities where arbitrations can happen a lot faster. For instance, just on the transcription services, a cross-examination that can, that goes on for 5 days in the question-answer format can be shortened to about 1.5 days just by transcription services, because you're saving so much time just putting that whole Q&A format. I think these are some of it, and obviously on the legislative space as well, there have to be some key amendments, and you know how the judgments of the Indian courts also have been, especially from 2015, while they have been largely pro-arbitration. Some judgments have gone here and there, but I think
there is a dearth of consistency in them.
That's true. There's definitely a dearth for consistency, but I would say that compared to before, we have reached a much more comfortable spot insofar as having a more pro-arbitration approach in all the judgments across the country. I think judges are also a lot more sensitized now, though of course it has to be consistent across the country. But I would say largely the mood and the tendency is to be a lot more pro-arbitration.
Yes, the flippant nature of the courts is best described through the latest Cox and King's judgment, in which the phrase from the popular Bollywood song "Idhar Chala Main Udhar Chala" was used, which could be used to describe the state of arbitration in early 2000s in India, where the positions of law were changing every 4 years. And I think to address such challenges even today that arbitration faces, the government has formed an expert committee to implement changes in the Act itself. We've had the 21 amendments in 2015, 19, and 21, and we're set to have another round of amendments and changes. If you were given the opportunity to make one of those changes in light of the recent rulings, such as non-stamping, such as the group of companies doctrine, what would be the change that you would like to make in the Act itself?
So thanks for that, Aditya. Again, this requires probably a 1 hour session because there are lots and lots of suggestions. In fact, our firm has also given some suggestions on what can be done. So a bunch of lawyers have come together, and the India Arbitration Forum, which is a forum of lawyers across the country, we've also given our recommendation. But broadly, I think some key aspects like enforceability of foreign arbitral awards. There was absolutely no clarity on that, and I think this whole aspect of stamping itself, I think my personal view is that it has been just completely blown out of proportion. I don't think the concept of stamping should be there in the first place. Again, that's my personal view, because if you want to make a particular jurisdiction arbitration friendly, and typically you give SOPs to industries, right? If you want industry to thrive in a particular place, you give SOPs. If you want to make India an arbitration hub, why have this whole concept of stamping on the arbitration agreement itself? And in some jurisdictions, even an arbitral award needs to be stamped at the time of execution. I cannot tell you the number of cases that I had to just tell the clients, I'm sorry, this is what the provision is. We cannot do anything about it. And the client just raises his hand and says, I don't want to enforce because for a 600 crore claim decree, they have to pay stamp duty of something like 65 to 85 crores. And it's like the client says, I don't want to spend more money on this litigation because the chances of recovery are a lot less. So the entire thing was just written off. So a lot of instances like this where I think there needs to be a lot more discussion on, why there is a need for stamping in the first place. I mean, everybody speaks about the old judgment saying that, we all understand the 2013-14 judgments onwards, the fact that stamping goes to the root of it, etc., etc. But I think we need to take a policy decision on this, on whether it is required or not. I think that is very, very important. And I think on the group of companies doctrine, the latest Supreme Court judgment has made that very, very clear. And like this, there are several other amendments. For instance, Section 37 of the Arbitration Act. While there is a clear guideline on how Section 34 needs to be interpreted, which is that it is very, very limited, etc. But what happens against an appeal from a Section 34, which goes to a 37 court? Now, there are no guidelines on that. And I can tell you some of the courts that I have been to treat Section 37 to be pretty much like a first appeal, where they go into and review all the merits. So, some kind of a legislative intent there saying very clearly that it cannot be more than this would really help. Though, of course, I think it's understood that 37, the scope is very, very less. But I think a lot of it needs to come from legislative amendments and not judicial interpretations.
Yes, we need the government to make it clear that the idea of arbitration was to settle things outside of court, not give courts more opportunities to interpret another act itself in its entirety
Yes.
since its inception. Upon that, building upon how one should succeed in this profession, what do you think? Are the necessary, are the imperative skills? What should one have in their skill set in order to be a successful arbitration counsel, a litigation lawyer in general?
Okay. So let me answer this mainly from the perspective of to be an arbitration lawyer. See, one of the biggest myths or the mistakes that law students make is they believe that the practice of arbitration is knowing the Arbitration and Conciliation Act 1996. It is not so. Just knowing the procedural law is not enough for you to be a good arbitration lawyer. A lot of people tend to focus on Arbitration Act, the judgments, the sections. Of course, it is important. I'm not saying that it is not important, but that is only on the procedural law. But when it comes to the actual application of your skill in an arbitration, there are a lot more than that. One is your ability to read and understand the nuances of the evidence that you need to leave. What kind of evidence should you leave? What is the evidence that is led by the other side? What are the issues which are framed? How to cross-examine a witness? That itself is an art. What are the kind of things that you need to elicit from the witness? That also is an art. What to cross-examine, how to cross-examine, what not to ask a witness in cross-examination. These are all skills that you do not get just by reading the Arbitration Act. These are skills that you learn by being a really good civil lawyer. So the number one advice is that arbitration is not only about the Arbitration and Conciliation Act. Number two advice that I would give all law students who are interested in the practice of arbitration is to become really good civil lawyers first. I would say that before you specialize into arbitration, spend a couple of years in the city civil court, understand the nuances of how cross-examination happens, how evidence is led, and see the suit through and through, right from the date of filing the suit all the way till the arguments. See how the stage progresses and get exposed to all kinds of litigation, not just civil and commercial matters. It could be for instance, your criminal law as well. Understand how bail works, understand how anticipatory bail works, white collar crimes. Get exposed to everything. Don't say no to anything. And especially civil laws is extremely important. And let me tell you, even if people who want to specialize in tax, a good tax lawyer is somebody who knows not just the Income Tax Act, but also has a mastery over the civil laws. A person who does not have good mastery over civil laws cannot become a good tax lawyer. Likewise, somebody who has a good mastery over civil laws can become an excellent arbitration lawyer, because ultimately, whatever skills you have, whatever knowledge that you've gained, learning the nuances of various types of civil litigation, you put it in a more sophisticated, refined environment of being before an arbitral tribunal. Ultimately, it is the same, because it's only the procedures that have been cut down. It's a lot more sophisticated. You don't have to worry about applications being filed, reply, date given to some other date. Everything happens a lot more quickly. But your ability, I emphasize, on leading evidence and trial becomes extremely important. And your advocacy skills in an arbitration is also very different. And this is the third tip that I would give the colleagues, which is that, unlike a writ petition or something that's filed in the High Court or Supreme Court, where there's a margin of you could get an interim order or you could not get an interim order. You get a senior advocate, face value, and you try and get the order. There is no question of any face value or discretion thing as much in an arbitral tribunal. Arbitral tribunal will go only on the basis of facts, and facts cannot be changed. If a junior colleague with few years of experience has read the law fully, has read the facts fully, has thought the file through, gets a little bit of experience in terms of trial, etc., will be able to take on a senior advocate on the other side. And that is the beauty of an arbitration, which I personally have been able to do with 8 or 9 years of experience, matching wits with somebody who's on the other side who's 60, 65, a leading senior advocate. But you're able to do it because there is no discretion involved. It's all a question of just hard facts. And sometimes you may have more time to read than a senior advocate on the other side. So that's again another advantage that you have. It's more like a leveler with your experience, with your knowledge. You will be able to come on par with somebody else who's there. The other thing I would say is that it's the art of drafting again is very, very different in an arbitration compared to a court scenario. And that is something that's an ongoing process. You learn from your peers in India who are a lot more experienced, and you also learn from international arbitration lawyers, their ability to put a very, very complicated sentence or a message in a very simplistic form is absolutely beautiful. And without having to repeat it 10 or 20 times like we Indian lawyers are used to, because we say it is submitted, it is further submitted, it is reiterated, you go on, say the same thing multiple times. But the art of simplifying is something that you need to learn in an arbitration. Your ability to simplify a complex problem in a very, very simple manner, such that even an arbitrator or a judge would be able to understand, is another, I think, key thing that you need to look at. And I can go on. I mean, there are so many anecdotes of arbitration lawyers that I have met on the other side, people who have not had exposure to civil trial and civil litigation, who have made mistakes in arbitration, such as objecting to marking of documents, the fact that objections need to be taken at the right time. They don't even object to the introduction of the document. And at the time of final hearing, they come and say, oh, I did not object to it. This is an arbitration, etc. Sure, it's an arbitration. You're not bound by the rules of procedure, but the arbitrator still has to decide the case based on law. And the law requires that certain objections have to be taken at a particular time. Otherwise, that objection is waived forever. And those are things that you learn being in the city civil court, where you get your fingernails dirty. The first few years, you know what it is like where the other side tries to pull a fast one on you. And where the judge is giving you a hard time and you're trying to get your objective on time. Those are the kind of experiences that you can quickly bring to an arbitration, which is a lot more, as I said, a sophisticated environment where you'll be able to blend into that environment a lot more.
I get that there is recognition of the need to develop such skills more and more, even in law schools in India. As you can see, there's a meteoric rise in the number of arbitration moots that are conducted in the country. And I believe that you can also see that moot court associations or colleges in general have started introducing more arbitration award writing competitions, as which you pointed out is something that is very desperately needed in the realm of arbitration. So if I were to build on what students need to inculcate, what students need to develop, I think that one of the main problems that plagues every law student is how to get internships in the tier one law firms, especially in the disputes team, which is always has no dearth of applicants, it has no dearth of personnel. So, what would be your advice to people, especially as someone who's also faced rejection from such law firms in internships and placements? What should a student do to secure such internships?
I think one, be persistent, and I think a lot of tier one firms, including CAM, we have a very robust internship mechanism where we have tie-ups with pretty much the top law schools in the country, where the placement cell or the internship cell of that particular law school would send in the shortlisted resumes, and then we look at those resumes and then we get people on board. Because otherwise it becomes very hard for us to look at every request that comes to individual partners, either on LinkedIn or on their personal email ID or on the official email ID, and sometimes to multiple partners within the same firm. And sometimes multiple partners, including corporate partners in the same jurisdiction. So you can sense that, obviously they're trying really hard to get through. But as I mentioned earlier, unfortunately, the slots are limited and we really have to go based on a particular criteria that we have. But having said that, I think CAM takes its internship policy extremely seriously. And all the applications that come in, particularly through colleges, there is a very, very robust mechanism. There are partners, who dedicate their time. A lot of time is spent actually screening the resumes, both for internship and for recruitment. So no internship application is just left like that. So one, I would say that definitely try to route it through your through your campus. I think that happens a lot more seamlessly.
Yeah.
The second thing I would say is that try to be as original as possible. At the same time, don't be original only for the sake of it. It's very easy to see through it. Be honest, be true to yourself, and just be who you are. And even if internship opportunities shut in a particular tier one law firm, that is not the end. Because a lot of people I know who have not made it through internships, who have ultimately, have got placed because they were able to improve their grades at a particular point of time and they get through campus placement, or they work in other places and by virtue of their work experience, they come back to CAM into the ecosystem. But the doors are never shut. You just have to put and the third advice I would give is don't be dejected on account of this. It is not a reflection of how good you are. It is definitely not a reflection of the fact that we've rejected and therefore there must be something wrong in the candidature. It's just a problem of having too many resumes, which all of us face with in all aspects of life, including law students trying to get into law schools, right? How many people get into top law schools? It's only a handful of them who get through. It's because of the numbers that are increasing over a period of time. So I would say don't get dejected and take it within your stride and try to work somewhere. It doesn't have to be, even if you don't get through a tier one firm, but just continue to intern. If it is not a tier one law firm for internship, let's say for disputes, try and work with a senior advocate or try and work with the chamber. No knowledge that you gain goes for waste. And it can be any area, any facet of law. As long as you're interning, as long as you're working, you are gaining knowledge. So just keep that in mind. Approach all of this with a knowledge-oriented approach and not really a market and recruitment-oriented approach. The moment your end goal is to get a job and I'm doing everything just to get a job, the next person I talk to would be about what connects I can make. The next person I talk to would be who can refer me where. If your approach is that, then people can see through it. If your approach is a lot more genuine, where you genuinely want to learn from market leaders, where you genuinely want to gain from the other person's experience, share knowledge, gain knowledge, that is the way to do it. For instance, I can tell you there were people who have written to me, students who have written to me, and I can make out their intentions was largely to, critique a particular article that they've written, or sharing some article that they've written, telling me that they've done this, etc. Or they do some internship here and they go back and say some aspect of what you argued before court resonated with me. I decided to write an article. They share that with me. That I think is a much deeper connect to have with a law student. That is a way in which you also build your network as well. Not just exchanging cards and adding somebody on LinkedIn, but I think the connection has to be a lot more meaningful and a lot more deep for relationships to sort of translate into trust, where the law firm partner also feels that this person is good enough and I need to get this person in my team.
That was really wonderful advice. It really taught me a lot as well as a law student. Alluding to the paucity of time, I would request you to whatever advice you would have for aspiring law students and young lawyers today. What would your message be to them?
I mean, firstly, giving advice is the easiest thing to do. So I will not be the best at giving advice because I'm not sure how much I have followed it myself. But I can broadly tell you from experience of having seen a lot of law students and a lot of law students coming to me for advice. One thing I would tell you, which I mentioned earlier also, is not to get into a rat race. And always look at yourself, look at what your strengths are, and take the journey forward and treat it like a marathon and not like a 100-meter sprint. That is one. The second thing I would say is, when you're reading the law, understand the law deeply. And don't just study or read for the sake of getting your grades or marks, which all looks very fancy, which is great. But understand the law for what it is. A lot of people don't understand the interplay between various statutes. See, law is, it's like a human body, right? So you have multiple organs that are working together. We seem to take only one organ, like a heart, and say, okay, this is the arbitration law, and go gung-ho over the arbitration law, read everything on the arbitration law and forget about the rest. there is a lot of interplay between arbitration law and a lot of other laws. Not just the other laws, but also other sciences. For instance, it could be your economics. It could be psychology. Multiple subjects, there is an interplay insofar as law is concerned. It's very, very important to understand that interplay. So the other thing is that it's very, very important that you get an overall exposure to all kinds of laws, overall exposure to having an integrated approach to understanding other subjects as well. Because I can tell you from experience that as you put in more years, it is not just your ability to just cite section numbers from the IPC or the CRPC that is going to hold you in good stead, or from the Arbitration Act. It is your ability to understand why that law was there in the first place, the socio-economic impact of that, what was the policy decision behind it, and how the court has interpreted some of the other similar fiscal statutes similar to the Arbitration Act. I mean, just to give you a broad context of how they could be an interplay, I think that is very, very, very important. And the other thing I would tell the law students is I don't think you should take yourself so seriously or life so seriously, especially in law school. I see a lot of them being extremely stressed about their careers, and it is indeed a stressful situation. But I think somewhere if you just back your strengths, if you're just willing to work hard, and if you're willing to persevere on a daily basis, sky is really the limit for success in this profession.
And I believe that brings us to the end of the conversation. And I would really like to thank you for your valuable time and your invaluable insights. And I know for sure that many of our viewers today have been inspired by you to, very soon, someday meet you at the other end of the chessboard. And hopefully, high stakes matter. We thank you once again. The Contemporary Law Forum is forever indebted to your grace and for allowing us your time. Thank you so much, sir.
Not at all. My pleasure, Aditya. And I must compliment you and the Contemporary Law Forum for doing a fantastic job. And I think it's very important that you're spreading the message and you're interviewing as many people as possible, just so that knowledge is shared with aspiring law students. And I wish you, and I wish all the students, and I wish everyone who's listening to this all the very best. You're definitely going to be on the other end of the chessboard. And I'm fairly sure not just be on the other end of the chessboard, but also make some fantastic moves such that you're able to beat me as well.
Hopefully, sir. Thank you so much.
Absolutely. Thank you. Thanks a lot.